A Toronto dad and university lecturer is going public with his plea to the Prime Minister to change a discriminatory law that impacts LGBTQ parents. The law prevents gay moms and dads from accessing the same tax entitlements that heterosexual couples receive when they start their families through in vitro fertilization. The CRA has repeatedly denied Ken McNeilly's tax claims for tens of thousands of dollars in expenses related to the surrogacy of his eldest child because Ken is gay and the surrogate isn't his spouse or common law partner. Ken McNeilly is live tonight with us. Thank you so much, Ken, for being here. Can you walk us through this law for some people who may be unfamiliar with this? You say this creates unfair and unnecessary barriers for LGBTQ Canadians who want to start families.
Sure. I've had to become a bit of an expert by necessity in the Income Tax Act of Canada, and the definition of patient that they allow for anyone submitting medical expenses is quite narrow and doesn't perhaps imagine the way people would one day become parents. So a lot of people access fertility treatment in their desire to become parents, but for straight couples that eventually themselves become pregnant, all of those expenses are deductible. It's for LGBTQ Canadians and some other folks as well that don't have access to submit those same medical expenses. They don't have access to that tax credit because of the narrowness of that definition.
Have you ever gotten an answer to exactly why is it okay for one side but doesn't pass on the other side here? What's going on?
There's been no good explanation. One of the sort of cop-out responses is that there are a few straight couples that also need the help of a surrogate to have a child, and these expenses are denied for them as well. And so that's kind of the excuse that is sometimes used to say, oh, no, it's not discriminatory, but this has a disproportionate impact on the LGBTQ people who desire to become parents themselves.
Right. Okay. So let's talk about your sort of background here. You tried to conceive a child initially in 2015 with the help of a Canadian fertility clinic. That wasn't successful, but you were able to get a surrogate in Nepal who then became pregnant with twins. What happened from there?
My twins were born in February 2015, premature because of the riskiness of a twin pregnancy. And sadly, my daughter, my firstborn child, passed away at 27 days of age. I returned to Canada 6 weeks later with my son, who is now 5 years old. And, after all the challenges of becoming a parent, trying first in Canada, then having success in Nepal, then losing a child, it was more than just a slap in the face to know that I would face yet another barrier, which is ongoing today, years later, as a result of something that is essentially systemic discrimination baked into the income tax law in Canada.
And I mean, you also incurred, about $30,000 plus in expenses related to IVF, sperm analysis, storage, egg retrieval, embryo testing, storage. I mean, the IVF procedure and medication for the surrogate, those are big costs. But the CRA say these expenses weren't for a, quote, patient because the surrogate isn't your spouse or common law partner or dependent. You've already sort of talked about the fact that for heterosexual couples, the surrogacy sort of cop-out, as you called it, exists here. But I mean, you're still raising that child. You're still bringing that child into the world as a parent.
That's right, and the costs for a heterosexual couple that require help from a fertility clinic, those costs can be submitted, and this medical expense tax credit is available to them. So not only do some parents have the extra financial burden of needing a surrogate to help them achieve pregnancy, but then they're further economically disadvantaged by the narrowness of this discriminatory definition.
Okay, so you're asking the Prime Minister to change the Income Tax Act to be more inclusive to LGBTQ plus parents. What's the status of the ask?
I first, it was my 2015 taxes, and so filed in 2016, a reassessment in 2017 that led to my first attempt at an appeal. And there was lots of back and forth between the lawyers for the CRA and myself. And eventually I was able to secure the help of McCarthy Tétrault, a law firm that is going to bat for me now. And we have removed the case from the informal procedure of the Tax Court of Canada and moved it to the general procedure. And so that appeal has just been filed within the last couple of weeks, but we're still looking at about a year and a half from now before that's actually heard in the Tax Court of Canada. So my plea to the Prime Minister would be, let's get this done at a political level rather than waiting for it to go through the court process. It's clearly discriminatory, and it'd be much preferable for so many reasons, not the least of which is saving taxpayers a lot of money, if we would just cut to the chase and get this done, change the definition in the Act.
Okay, Ken McNeil, keep us posted and let us know how this all goes. Of course, your court challenge to the Prime Minister. We'll appreciate this. And